Good afternoon or morning, depending on where you are. I'm David Graham, and this is the third installment of our series on government investigations. Today, we're going to talk about search warrants and what you should do when facing a search warrant and when the agents come to see you unannounced and want to come in and talk to people and take things. My experience with this, you're probably wondering, what does a civil litigator and regulatory lawyer know about search warrants? My experience is completely by chance, and I've happened to be called or at facilities for 5 of them. And I guess maybe that's just the way it goes if you've practiced long enough in the area. So I was involved in 2 that were companies were the target. One where an executive was the target, but not, and it related to regular, FDA matters. And 2 where people working at the facility where I ended up when the warrant was being executed were being investigated for something that had nothing to do with what had to do with the company, but it had to do with them ripping off the company. So in any event, I've been on the premises and over the years have tried to develop, even though you don't know when they're going to happen, and I'm not a criminal lawyer. It's good to be prepared, and if you work in-house to know, or an outside lawyer that works with in-house counsel on regulatory matters and in heavily regulated industry, then maybe it's good to know about search warrants. And I wish at the first one, I wished I had known what I know now. And so I hope this is of some use. I hope the other presentations have as well. And please ask questions. I have somebody monitoring the chat. I'm not great at that, but we leave time at the end for questions as well. All right. So here are the things we're going to discuss. Basically, what are the legal reasons and what are for and what are search warrants and what can they take and how do you be prepared? How do you respond? How do you deal with employees? And kind of some absolute what not to do's and what happens afterwards. It's important to not think it's over when it's over, and you wouldn't. It's a little bit, it's not a great feeling you have, and you're always wondering what your rights are afterwards, and we'll talk about that a little bit and how you might respond after the warrant execution is over. So the exclusionary rule I started with, not to give you a law school primer on the exclusionary rule, because I probably couldn't do it. All I know is that if you, I know that evidence illegally obtained can be quashed before it's so it won't be admitted into evidence against you. Well, how do you do that if you're just, you show up at somebody's business and, the warrant search and seizure is about to begin, and how do you have any control over something that could happen months, maybe a year later? And what do you do? And the thing is always to do is object early and often and do it in writing. So and we'll talk about this more as we go through the presentation, but basically is if you're prepared, you will have in mind objections you can make either to the breadth of the search or the character of the warrant itself or how it's being conducted. Not that you'll stop the warrant from being executed. That's not going to happen. And I'll give you some tips how to do it in writing before something happens. So you can say, if the officer says, I want to go see this part of the company, and you can say that part of the company has nothing to do with your warrant. Obviously, you're not going to stop the officers. Remember, they're cops. You're not going to stop them from going there, but you can hand them something and say, and make a record of in your notes, which we'll talk about, that the officer wanted to see X, We told them that X had nothing to do and does not fit within the scope of the warrant, and go on. And whatever happens, it might relate to privilege, or it might relate to certain how they're conducting themselves with employees, or other things like that. So just remember, whatever you do, and however uncomfortable it feels at the time, because it can, make sure you object. Even if you just say something, I object to you taking these files, and you say that, and hopefully maybe you just make a note in your notes, so you can say, I objected at 10:42 to agent so-and-so who wanted to see files related to a product that has nothing to do with the warrant, or something like that. Obviously, the more detailed, the better, but sometimes it's difficult to do because things move fast. So what is a search warrant? Well, a search warrant is an authorization by a judge. So I'm going to read this because it's pretty specific and instructive. An authorization by a judge to allow law enforcement officers to search, and that's important that they're law enforcement officers, to search a particular location and see specific items. That's important. We'll talk more about, based on a showing of probable cause that a crime was committed and items connected to the crime are likely to be found. So that's search warrants. And you probably have seen discussions about search warrants maybe on TV, or maybe you're criminal lawyers and you do this more. But the same law that applies to the, an officer stopping your car and searching it and you're not sure why, that all the same rules apply to that, to the FDA or DOJ people coming in, or FBI into your company and looking for people in files or other evidence. And so the rules aren't different just because you're in a sophisticated regulated industry versus the citizen on the street or in their home or wherever they might be. So what are your protections? Well, you have the Fourth Amendment. Fourth Amendment is the underpinning of all protections for searches and seizures. I cannot begin to go through all the laws that apply to it for every state, but generally we'll flesh that out as we go as it relates to warrants. But just remember that you are protected by the Constitution from unreasonable searches and seizures, and unreasonable is, a reasonable person standard in a lot of ways. Well, obviously there's laws about it, and Supreme Court decisions. We don't have time to get into that here. And you usually don't have time during a warrant to argue about particular cases that relate to searches and seizures as it would apply to federal agents. So for maybe another time we can do that, because it is interesting law. But basically, for the purposes of this presentation, you should understand that they're coming in. You shouldn't stop them. You should make objections when you can, as fast as you can, and try to preserve those objections as long, all through the process until the trial. So the difference between a search warrant and an inspection, we talked about this before, and it's probably obvious, but I want to make it more obvious. An investigation is something into some specific event or events that are happening. Inspection is, I'm coming to see if you're complying with a whole bunch of things as it relates to GMPs and sanitation and whatever else it might be that a general FDA inspection would involve, or USDA inspection for that matter. And you get a 483. Well, hopefully not. Hopefully you work through it so you don't get one, but you get some kind of report. You have a chat at the end, a closeout meeting to try to resolve as many of the notes that the FDA has taken about their inspection, and you hopefully correct most of them immediately and some of them soon after, and so it gets taken care of. This is a whole different thing. This is something specific has occurred or is occurring, and they're investigating it. So one of the mileposts or one of the orientation places is how specific is what. Let me say it this way: how is the warrant being executed as it relates to what I'm being told about what is the subject in the investigation? So that's a question you should always be asking yourself as the warrant is being executed. Again, you're not going to stop it, but you can make objections along the way and notes along the way and kind of track what's going on as it relates to what the officer said they are supposed to be doing and what the warrant is supposed to, how, or as it relates to how the warrant is supposed to limit what they're doing. And the admonition will keep saying you can't keep them out. Well, you can keep them out. If you're a rancher and some on, grazing your cattle on federal lands, apparently you can. But other than that, it's not a good idea to try to keep people out. You don't have really the right to do it. All you can do is object. And I think I know you'll make things much worse for you if you, do any more than question what's going on. So don't do it. What are the requirements of the search warrant? Well, it has to be filed in good faith by an officer. That means the DOJ or some other FDA official has to go to a magistrate and say, hey, I want to go to company X because we found out we are getting information from somebody that's credible, a whistleblower, that they're filing fraudulent claims for payment. And it's beyond just, a civil false claims act thing. We think there's, theft going on here of the government. And, or whatever the situation might be. It might be dangerous products. We got information that something's being manufactured that if it gets into people, it's going to cause harm. So it has to be reliable information. You can't just take a phone call from somebody, right? So usually an investigation has been going on before search warrants are executed. People have come forward. Government has tried to interview people. The government has done research on what's going on, maybe as it relates to that class of products or something like that, whatever the case may be. And so a search warrant is usually backed by, some significant investigatory evidence that's been accumulated in advance of it. So it has to be issued by a neutral and detached magistrate. I know the judiciary might be taking their lumps these days, but most of them are neutral and detached, don't know the agents, don't know the company, maybe. Or if they do, they don't have a relationship, and they'll evaluate the request and ask questions about the request and help hopefully make the agents, limit what they need or are seeking, or at least be specific about what they are needing and seeking for their investigation and for evidence, and why they can't get it another way. So good judges will ask, well, why don't you just send a subpoena, right? Why don't you talk to these people? And then usually the officers have to give a reason. Well, we think it'll get destroyed. We hear that they're not conducting their document retention as they're supposed to, and evidence we think will be lost, and whatever else might be the exigency that leads to the need for a warrant. And then it states specifically the place to be searched and items to be seized. So we'll talk about this in a minute, but you got to know, right, when they come in. This is one hook you have, right, to kind of have a little control, or at least a basis for questioning and sort of organizing your own analysis and observation of what's going on is, what does this warrant say about what they're supposed to be doing? And they're usually pretty specific. So hopefully judges are making the officers specify things. So usually they don't come in and say, the whole company is available to us. They usually have, we're looking for this. We want to get these kind of files. And then, if that files means taking computers, they might, and things like that. What can be searched and seized? Only the areas described in the warrant, which we've just said, but just so it's clear. So if right away you might meet the agents at the door and they're here, we have a search warrant. Can I see the search warrant? Yes, here's a copy of the search warrant. Give me a minute. Can I read the search warrant? Usually they'll let you read the search warrant, right? And then if right away, you ask them some questions. And if there's a disconnect between the warrant and what you're getting from the agents, then make an objection right away. And that doesn't mean you're going to stop them, and it doesn't mean you're going to be helpful, right? In other words, showing them where things are and things like that. So it's important to know. So as far as seizure goes, only the specific items called for in the warrant. Sometimes that's not very specific. That's all files related to, all computers that might contain information related to whatever the subject matter of the investigation is. And so it's important to understand that it's never crystal clear. I wish I could say that, somehow I convinced agents not to take things that I thought were outside the bounds of the warrant, but they do, because they don't want to come back. Even though there's usually cleanup afterwards, they want to be as thorough as possible. And believe it or not, it doesn't help them if they're overly disruptive of your business, because business, even if you're subject to a warrant, doesn't mean business stops. Doesn't mean you're done for the day or anything like that. Business goes on. What are exceptions to these limitations? Protect the safety of the officers or others. Rarely is there a situation, at least there hasn't been in the 5 I've done, where any agent just said, well, I need to go beyond the bounds of what the warrant says because I'm worried that somebody's going to get hurt. I mean, somebody in the process of executing the warrant, usually that relates to police going in houses and places like that to get violent offenders and things like that, so the neighbors don't get hurt or some, whatever else the case may be. Not usually a reason that should be given by a federal agent executing a warrant in a DOJ investigation that relates to, we'll call it white collar crime for lack of a better description. To prevent the destruction of evidence, I've heard that one. And because in one case, somebody had reported, well, Mr. Graham, we understand that you're not following your document retention policy and people are destroying documents before they're supposed to, before the retention period expires, and et cetera. I have no way to verify that, but at least they gave me an answer that, at least in that situation, was circumscribed enough to where I could say, well, what evidence? Was this in this department or that department or whatever it might be? And so we could not say suddenly, because you think evidence is being destroyed, there's no limit on where you can go in the company or what documents you can see. Plain view is one, of course, that you see on TV all the time. Not common in white collar, especially when everything's on computers. So nothing's in plain view, right? Although they could argue, I suppose, if you turn on a computer which we've had to do for an officer and tell them where to search complaint files, For example, they see something in the complaint file. I mean, nobody's ever made that argument that since I'm looking at this complaint file and then I see something that looks suspicious in it, I get to take it where I otherwise wouldn't. The plain view is I walk into a house and I see, because somebody's there with 20 pounds of cocaine and I see, some other offense related to abuse of somebody or something else bad going on, and I can deal with that as well because it's in plain view, or documentary evidence that might not be specifically set out in the warrant. Well, how do you prepare? Well, it's basically the preparations you would for inspections. So if you have a team of well-trained people and a team that deals with inspections, inspections, I would use that group if you have a big enough company that allows for that, to be the head of the response in a warrant, right? Because they know what the plan is for inspectors. That shouldn't be much different for officers coming in. I mean, in other words, how to communicate with the company or the employees in the company. Have a point person or add a person if you don't already, or a lawyer who understands warrants. You don't have to be a criminal lawyer to do this. It's not necessary because the criminal lawyer part is important at the time of the execution of the warrant, but it's even more important when you're dealing with who gets into custody or what information do we need back, and fights about scope to come after the execution of the warrant. Have a communication plan, and you should have that for when inspections occur already, so information just doesn't go steaming through the company and end up completely wrong and completely freaking everybody out and causing people to leave, right? While a warrant is being executed, which is a really bad idea, but people get scared, right? They don't know if they're involved in something or not. They have no clue. Maybe somebody will hear that the cops are at the door and I'm out of here, right? Maybe for some other personal reason. So not that it's a lockdown situation, but if you train people and have communication plans about what happens, you can kind of ease the tensions there that get ratcheted up when search warrants are involved. And then do some training so they can understand, somebody someday might come and say, I'm going to come and look at XYZ. I want to talk to your employees, and here's the ones I'd like to talk to, or at least the ones that might know about the subject matter of the investigation. And so talk about it and and then we'll talk a little more about what you would tell them. And maybe you can get people to handle it in the most professional manner possible, which most companies do. So when you're responding, immediately contact the people that we just talked about, who's designated to deal with this. And then hopefully that person, if they're not a lawyer, knows to call a lawyer, and that lawyer's already known, and no matter what time of day it is, either that lawyer comes and helps out or is there. And if they're not around, so you need kind of a list of 2 or 3, right? Because there's no way to predict where everybody's going to be. Control the information flow. That's by designating one person to deal with the agents. And so if that person, I think you need more, depending on how many agents there are, right? If there's 4, you need 4 people. One to follow each agent and take notes and add some, kind of be a liaison with the employees without getting in the agent's way. You can do that. You can say, Mr. Jones, this is Officer so-and-so, and he wants to talk to you about this. You're executing a search warrant. You don't have to talk to him. If you're a lawyer, you can give him that advice or whatever. Or this agent just wants to ask you where things are and then tell him, right? because you want to be helpful without volunteering information. It's one thing to respond to a question about where things are that's specific. I need documents about the quality control plan for X product between so and so, time frame or whatever it is, maybe the last 18 months. And so you find that person and they show you how to find it. So review the warrant for time frame in the investigation. Sometimes there's information on the warrant that kind of describes what's in the background, right? It's not always tremendously helpful, but some, so you can get an idea about what's going on and what has been going on that led to the warrant, why your company's involved. Your company may not be a target, right? But they might be a person in the company in sales or something, or so you got to try to sort that out. What types of data are specified? Like we discussed, it's not always a perfect description, but it gets better and better. The government agents are pretty good about understanding what companies have. And then what are the limitations on the search? Sometimes it says right in the warrant, don't you know exactly what they're supposed to get and where they're not supposed to go. This does not include XYZ. Judges don't often demand that, but sometimes. All right, what do? You monitor the agents, who and how many and where they go and what they do, and document communications with the agents and their search activities. So, I mean, detail as you possibly can, right? Without looking over their shoulder completely and getting in their way. You can even ask them, what are you doing, right? I mean, generally, what are you doing question. If you really don't understand what's happening, right? With some equipment or some product or whatever, a lab, whatever it is. Are you planning to take that with you? That's a question that's legit, things like that. Protect privileged documents. Protecting privileged documents does not mean stop them from taking them. It means telling them that they're privileged. And so that's important to do. And try to get as many as you can and be as specific as you can. And hopefully they're organized enough within systems so you can kind of identify them or tell them how they're marked. Doesn't mean they're not leaving, but it means that you've made the objection and that no judge can say you didn't care, right? And why didn't you say anything? So now it's out, right? None of that argument. You want to cut that off. You may lose some other privileged argument, but not that one. Then, so preserve and obtain critical documents to maintain businesses. That means not, again, it means getting copies. Look, we can't operate without this computer or these databases. You can't lock them up. I mean, I understand you need the evidence, but we have to be able to operate. And you should be able to, in almost all instances, work with the agents so you don't have to shut down, because that's usually not their intent, and they don't want to create damages that the government has to compensate the company for just because they were too lazy to work with you on that subject matter. Obtain an inventory seized item. Well, you can't get them back from the government, but you can, sometimes you can have them kept somewhere where, if the government's not taking them with them, right? If you have to sequester them somehow. Usually they just take them, but you want to know exactly what they took, because you're going to make. So all this documentation is for future motions about excluding evidence later, right? So if people are being prosecuted, you can say, well, none of that evidence was taken properly. Here's why. Here's our notes. We objected. We've always thought that it was improper and that warrant was executed beyond its limits, and whatever arguments that you have to exclude the evidence. Managing employees. This is we've talked about this some already, but these are just a few finer points that I think are really important. So, the warrants aren't scheduled at your convenience, right? They're not always scheduled just to make it absolutely a nightmare, but they're scheduled based on the information they have from who's ever giving them that information about when would be the best time to be there. And they do like an element of surprise if it's serious enough. And and they want to make sure they're there when the people they want to talk to are available to be interviewed. They cannot interview represented persons unless the person declines the representation and then wants to be interviewed. If they are represented in the particular matter for which they are being interviewed. So this is tricky, right? Because they don't know if they're a target or might be a target. Lawyer doesn't know if they might be. So you try to get as much information as you can about why that information is needed from that person at that time and can't be done at some subsequent time. And maybe because they think the person's going to take off, right? Then you find out, then it gets a little more serious about what they think about that person's involvement in the alleged offenses. Some interviews take place off premises before the execution of the warrant. So, we've talked about that, and people don't have to talk to agents, but they don't know that. It's frightening. And so train employees about interviews, which we will discuss right now. So they're not normal conversations. You should tell people, no matter how much agents want people to think they're normal conversations, they're not. They can be recorded and they're part of a police investigation. Police being FBI agents or DOJ agents or whatever federal agents are involved. And so there should be no illusions about you're just being chatted up, right? It may sound like that at the beginning of it, but eventually they're going to want information about alleged crimes. You're not obligated to speak with government's agents and should not do so without counsel. So you can just say, no, I don't want to talk to you unless you're listed on the warrant, right? But that's usually not how it goes. Hopefully they'll get lawyers and you can be involved in that process and find lawyers, or you, right, who can sit with them during the discussion. Because again, you want to be cooperative, right? And most people they talk to probably may have nothing to do with any alleged offense other than they work at the company and somebody is alleged to have done something with what they made or recorded in the company and used it improperly, might be the allegation. So, they'll probably tell the government agents how they do their job. And then they'll ask them about, well, we heard X and this was going on and that was going on, and most likely they won't even know. But sometimes they do. So partial participation can draw a negative inference. Either you're in or you're out. If you're being helpful, yeah, I'll talk to the agent. Please, counsel, sit by me. You represent me now at least for purposes of this interview. You got to get that all straight on the record. And then you proceed, you're in, right? And it's a much better situation than going, well, I don't want to talk about that. I don't want to talk about that. Yeah, right. If it's personally, if you are a person who thinks they know what's being investigated and thinks you have information that might implicate you personally, then you might say, I don't have the lawyer I want now. And I know company lawyer outside counsel, you're a great lawyer, but you're not what I need now. I might become a target and this is criminal and I need a criminal lawyer. Perfectly reasonable response. If you agreed to be interviewed, only tell the truth. That's obvious, but it's amazing how people don't understand. It's like in a deposition, right? If you're speculating, it's not the truth, right? So you got to try to convince people in training in advance that if you don't know, say you don't know, and be very clear about that. So, and then let them know that all answers can be used against them, right? Doesn't mean you're going to be able to say nothing, but it's they need to understand that. before going in. Now, usually that gives people pause. What not to do. Don't obstruct. We've talked about that. Don't destroy or alter, remove, or hide evidence. That includes people leaving. Don't consent to the search and seizure beyond the limits of the warrant. That doesn't mean you stop it. That just means you object to it. And you hand them, so I didn't talk about objections enough, but I write them up in advance, right? So the little sheets of paper. I object to the government agents doing X. And so people can just write in, the date and the time and what it is they object to. Then you can just hand it to them. It becomes part of the record. Keep a copy for yourself and your record of the execution of the warrant. And then we're off. There's not arguments. There's not people, trying to convince agents of something, because you probably aren't going to. They're just going to do it. But you've lodged your objection. Don't prohibit employees from speaking to agents if somebody comes up to the agency. I want to talk to you about this. Don't try to stop them. Say, hey, it'd be better if you did it with a lawyer. Well, have somebody sit with you. And then their answer's their answer. Hopefully you can convince them to have counsel there. Don't volunteer information without authorization. There's no volunteer information unless, the information is here's where this is and here's where that is. But when it comes to the substance of a particular matter in the investigation, just wait till a formal interview or at some point other evidence gathering event. Don't disclose privileged information. So that some people don't know. So that's hard sometimes when you get down the chain amongst employees. But if you're a manager or counsel, to object to that. So what's the follow-up? Well, the follow-up is sometimes they'll come back, right? And say, you know what, we just got some more information, and they'll send you a cleanup subpoena. We like this, this, and this. Usually don't come back unless, and at least it's not in my experience, but of course, my experience, 5 warrants. But usually it's by writing. And one thing I want to add to this follow-up slide is that you can send a letter too. Here's all our objections to what happened today, and send it to the lead investigator, and sometimes they send it to the judge who issued the warrant or signed the warrant. And just for the record, here's all the things here's where we think you went beyond the scope of the warrant. Here's where we thought you improperly talked to employees. Here where the conduct was out of line, or whatever it happens to be. There's no they've left and hope nothing happens. Keep the dialogue open, maintain open lines of communication. To the extent they'll tell you things, they're not going to just suddenly let you into their investigation and tell you exactly what they're doing. But vis-a-vis your company, your individuals, then, or your employees, then certainly sending information. And if you discover stuff that was clearly might be relevant, then you have to sit down with counsel and decide whether it's in the best interest of the company to tell the government you missed this. Because if you want to use it, right, in a defense for your defense, then it needs to come to light in a way that's fair and according to the procedural and evidentiary rules. So we have 5 minutes left for questions. I know it's a lot of information, and since lots of different things can happen during the course of a warrant that I'm sure I didn't capture, ask questions now, see what we can do.
Thanks, David. It looks like there are a couple questions in the chat here. So the first one is, how do you work with lawyers representing other parties who may be there when a warrant is executed?
So I think what's that meant by is what do you do with, say, a corporate lawyer that I mean, a corporate employee that might end up being a target and they want to have their own lawyer come to the execution of this warrant, which happens. Or you might say you ought to get one and you call it for, call that lawyer for them if they don't know who to call. And then now you have two parties both dealing with the agents in two different interests, right? Might be competing, probably are in some way, somehow. And you just got to work together the best you can and try to establish an agreement as soon as you get tougher in criminal law than just a joint defense agreement, but something similar to that to allow, to kind of at least cooperate in how you're documenting the warrant. You may not cooperate on anything after that, right? But at least how you document what's happening and how you're registering objections and things like that, and how you're interpreting the scope of the warrant. Hopefully you're in concert on that. So not always, but maybe you can find agreement. It's hard to do on the fly too, but you got to try to do the best you can. And I've had that because they had to call somebody for, clearly they were after an individual when the warrant was executed. Well, they were also getting company documents. The company was not the target, it was an individual. So you have to work through that the best you can and communicate, and hopefully you'll, have some agreement about how things should proceed, knowing, right, that you're not going to stop the warrant from being executed anyway. So that's my best answer there.
Great, thank you. The second question is, what judge would you call if you thought it was appropriate?
Good question. I've never had to do it. But the judge who issued the warrant would be my first pick. Hopefully they're around, right? But if the warrant's being executed at 8 at night, then what do you do? Usually the federal courts, and lots of times this will be in FDA regulated companies, it'll probably be federal agents or somebody working under the auspices of the federal government. And hopefully you call the federal court. They usually have a judge who's assigned to deal with stuff like this. The only way I can see this is happening if things get unsafe and agents get so unruly that damage is going to be done to a person or the company in a way that couldn't possibly be contemplated by the warrant or by the officers or by anything, right? And you're trying to seek answers to the questions, or at least get the judge to, to talk to the agent to say, hey, what are you guys doing? I got a copy of this right here and of the warrant right here, and you seem to be going beyond it. I don't know if that's useful. I just know from being trained on this myself that it can happen, and people have appealed to judges to get assistance where they think that things are just out of control in the execution of the warrant.
Great, thank you.
Others?
It doesn't look like there's any others in the chat. So I think we can go ahead and end it if you're ready.
Yeah, I am ready, and thank you everybody for joining.